Chapters 9 and 10 and Chapter 20 make up 51 total questions out of 102 questions on the test. Therefore, with Chapters 9 and 10 and 20, that's half your test. 50% of your test is made up of those three chapters. Chapters 9 and 10, 36 questions. 36 questions. At a minimum, a contract consists of, my definition, not theirs, a legal agreement between two or more competent parties where consideration is exchanged now or in the future. A bilateral contract, you will remember, is a promise for a promise, and in a unilateral contract, there is a promise for an act. We had an example in the book about executory and executed contracts. An example had something to do with a coal company had delivered coal to your steel mill. You were already burning the steel, and the deal was that you got a bill for that, and then you had 30 days or 60 days or whatever time to pay that. If the coal company had already delivered the coal and you were already burning it, meaning you'd already accepted it, but you hadn't paid yet, your part of the contract is executory. The part of the contract by the coal company is executed. You will have a question similar but with different facts. Contracts, as we know, can be in writing, they can be verbal, they can be expressed, or they can be implied. So pretty much they can be any of the above. Not necessarily all at one time, because the contract is usually written or verbal, and a lot of times if it's written, of course, it's expressed, but it can be verbally expressed as well, and it can also be implied. For an offer to be effective, we said that offers had to meet three requirements. There must be objective intent. The terms of the offer must be reasonably definite, and the offer must be communicated to the offeree. Suppose your uncle promises to give you $500 for Christmas, and before Christmas he changes his mind, and you want to collect your $500. You can file a lawsuit if you want to, but you really don't have any grounds because the contract is gratuitous. You have done nothing in return just because he promised you $500. Now, we did have the example where somebody agreed to pay you to go back to school and pay the tuition, and you relied on that. That would be different. But if they're just giving you money and you're not doing anything in return for that or relying on that, just because you went out and bought some clothes, that's not reliance. Okay.
What's that word?
Gratuitous. It's a gift. It's a gift. It's a gratuity, meaning it's a gift. An oral contract for the sale of an interest in real property is void or unenforceable under the statute of frauds. North Carolina, the statute actually uses the word void. I've looked it up.
Statute of frauds?
Statute of frauds. Lucy versus Zimmer in your book, remember, is a classic case involving contractual intent. It's not a case involving contractual capacity, as you might think, because he said he was drinking or he was using drinking as an excuse for his capacity. He was saying, I didn't mean to. We were just goofing off and playing around and talking big because we were drinking. A contract between a United States citizen and a non-resident alien from Mexico is valid. Aliens do have capacity to enter into contracts. They can I think they can even be an illegal alien unless there's not some new immigration law I don't know about. Of the various types of ways to terminate an offer and also to terminate a contract too, remember, we kind of looked at both of them, but in the book it started out by talking about terminating an offer. One way was to withdraw or revoke your offer. Another way was for the offer to be rejected. Another way was for the person to whom the offer was made to make a counteroffer. You could have the subject matter being destroyed, lapse of time, and supervening illegality. And if one of the parties to the contract becomes incompetent or dies, that's to terminate an offer. Okay. Remember we talked about preliminary negotiations or statements of future intent, like, hey, have you sold your stock? Well, I'm thinking about selling it, or I'm thinking about selling my car, or here's what I'd want for you if I was selling it, but I'm not selling it yet, or something like that. That's not really an offer or an acceptance. Usury, which we studied under illegality, is a charging of excessive or what we would call illegal interest. Now, the illegality here is often not criminal, but a civil illegality. But there are very complicated statutes about when something is usurious or not. Minors, of course, have the right to get out of a contract after they become an adult, unless the contract involves something which is what we call a necessity or necessary item, like your clothing or your shelter or food. But generally speaking, if a minor enters into a contract to buy something or sell something for that matter, then they can change their mind after they become an adult if they do it within a reasonable time. And I would argue doing it the same day you turn 18 or the next day would be very reasonable. Oh, cool. It has a picture of a microphone. That's neat. I don't see any new droids here. All these are Blackberries and iPhones. Okay. I saw a new droid this weekend. All right. Anyway. Okay. The equitable remedy for misrepresentation or fraud, remember, is rescission. Normally you want your contract rescinded. If you're lied to when you were buying a car about some material fact about that car and you find out about it, you want to get your money back and to give them the car back. That's restitution. There are various people who are able to sue and get money back or rescission of a fully executed contract. But there are some that aren't able to do that. If you have a contract with somebody who's not a licensed contractor and you've paid them in full and it exceeds $30,000, they get to keep everything you've paid them. You're not entitled to sue and get your money back because they weren't licensed. Now, if you haven't paid them yet, you don't have to pay them. So that's a case where you're not entitled to get your money back and rescind because the contract is fully executed. But if you have paid usurious interest, it's okay, even if you knew you were paying it, even if you knew when you got the loan that it was usurious, and even if you've already paid the interest and the principal back, then as long as you sue within the statute of limitations, you can get your money back. And again, some states you get double your interest back. In North Carolina, that's what it is. Counteroffer, remember, consists of a rejection of the original offer and a brand new offer. Therefore, the original offer doesn't actually exist anymore. Yes, it's a memory we have, but it's not part of the deal, and technically you can't go back to the original offer. I mean, you can certainly counter and recounter and eventually wind up where you were, but generally speaking, a counteroffer does terminate the original offer. Suppose somebody made an offer to purchase a car, let's say, because that was the example we were using in our book, and made the statement, this offer will expire unless acceptance is delivered to me on or before 5 p.m. on Wednesday, December the 9th. Well, and it turns out that before 5 p.m. on Wednesday, I call you back and I say, I've changed my mind, I'm revoking my offer. Well, I have the right to do that because I can revoke an offer any time prior to its acceptance. And just because I put a time limit on when you had to respond doesn't mean that I can't still revoke my offer before that time.